As we examined earlier, the First Amendment of our country's Constitution affords a great deal of freedom to gather and publish information, photographically or otherwise. It allows us to hold our government and public servants accountable. Also, as we discussed earlier, our First Amendment rights are not absolute. This is what United States Supreme Court Justice William J. Brennan had to say about news-gathering activities during an address at Rutgers University. The First Amendment must be balanced with competing societal interests. So, what might those competing interests be? When they conflict with certain rights of individuals. Unlike First Amendment rights to free speech and a free press, there is no constitutional right to privacy. However, most states have passed laws that protect the privacy rights and commercial interests of individuals, and the federal courts have generally upheld those laws unless they conflict with well-established U.S. constitutional rights. The First Amendment is often directed at the government, but the courts also recognize that any matter of public interest also deserves First Amendment protection in order to facilitate information about the society we live in. What happens in public spaces is a matter of public interest, even if the government is not involved, and the federal courts have consistently held the following to be true. Making photographs of private citizens in public places is allowed, even if they object. Essentially, if you can see it, you can make a photograph of it. Courts have ruled that if you're in public, you generally have no reasonable expectation of privacy. That said, it's always a good rule of thumb to respect people's privacy, unless newsworthiness and the public interest are overriding considerations. If someone asks not to be photographed, try and oblige them. There's almost always something or someone else to make photographs of. That's a bit of a judgment call, however. Just know that the law is on the side of the photographer in most cases. Additionally, in the news business, it's standard practice to identify everyone you photograph in a caption. If someone objects or won't give you their information, first try to explain how their photograph might be newsworthy. Remember this, you might have a right to photograph people in public places, but the people you photograph also have a right to question your activities. If they still object, try shooting someone or something else. It's not required by law, but it's good practice to talk to the parents of minor children you photograph in public whenever you can. They'll probably want to know why you're photographing their children, so tell them. Most parents are thrilled to have pictures of their children published in a news report, but some may have good reasons not to want the pictures published. You may photograph any activity that is clearly in public view, even if that activity is on private property. You may also photograph or record from private property, as long as the property is yours or you have consent from the owner and you are shooting something that is clearly in public view. For example, you can't ask a property owner if you can shoot pictures of their neighbor's backyard if it's hidden from the street. News gathering that involves criminal trespass could make you liable for unreasonable intrusion. Once you are asked to stop making photographs on private property, you must obey. However, know that private parties cannot confiscate your gear or insist that you delete your images. That is your private property, and they have no legal claim to it. Be aware, however, that if you hang on to your images, they can be used as evidence of your criminal trespass. In the case of a renter, you do not need permission from the property owner. Permission from a tenant to make photographs is acceptable. Private citizens are typically allowed a reasonable expectation of private space, even in public forums. Constant invasion of personal space, in public or private, can constitute unreasonable intrusion, and criminal stalking laws may actually be invoked if the intrusions are persistent and sustained. You may be found guilty of misappropriation if you use a person's image for commercial purposes without their consent. Well, wait a minute. Aren't news organizations commercial? The truth is, most news organizations are for-profit companies. However, courts have consistently ruled that content primarily meant to disseminate information is protected by the First Amendment, even if that activity is funded by advertising and other commercial means. By extension, most news gathering activities are also protected if they can be sufficiently linked to publishing information. The courts have been clear about what constitutes commercial use, while receiving some free speech protection. Advertisements, promotions, marketing campaigns, brochures, and even fundraisers by nonprofit organizations are examples of activity that is not fully protected by the First Amendment. They are subject to some federal regulation, such as the Truth in Advertising Act. In other words, uses that are explicitly intended to encourage direct commercial transactions are considered to be commercial use. On the other hand, publishing or broadcasting in the context of news, information, education, criticism, and artistic expression are protected by the First Amendment. Again, even if that activity is funded by advertising or other commercial means. A photojournalist or a publication may be found guilty of false light invasion of privacy if a person's image is placed before the public in a false or misleading light. For instance, you may legally photograph someone being arrested for indecent exposure during the St. Patrick's Day celebration. However, if you later use that photograph to illustrate an article on drug arrests, you may be held in reckless disregard because the picture places the subject in a false light. Misidentifying subjects is not only unprofessional, it can lead to lawsuits. If you have pictures of multiple people on file with the same name, for instance, make absolutely sure that the correct photograph is published with the corresponding story. Also, be clear about the purpose for which photos are being taken. Don't misrepresent or lie about your purpose simply to get a photograph. Truth or accuracy is not always a defense. Newsworthiness should always be the measuring stick. Be careful of gratuitous, embarrassing humor. Pictures should contain information of legitimate concern to the public, and or consent to publication must be obtained. Some subjects are the misfortunate focus of newsworthy events. The publication of such pictures should be the subject of vigorous newsroom discussion. The taking of such pictures should never be in question, however. That is a matter of private editorial discretion, and the prevention of publication, either by the government or private citizens, is censorship. The courts have consistently looked down upon such prior restraint. There has been one court case that found that the use of a telephoto lens was intruding, and some still cite this case for using caution with telephoto lenses. However, there has never been a finding for invasion of privacy involving the use of a telephoto lens while covering something newsworthy or of public interest. The courts will ask this question: were the photographs made with intrusive behavior, such as hiding or photographing through a slit in a window curtain? Or were the photographs made in the course of professional and legal behavior? That will determine the outcome, not the focal length of a lens. In the past, Courts have ruled that the practice of law enforcement inviting journalists onto private property for the purpose of covering newsworthy events is common custom. Journalists must leave only if the owner objects. More recently, however, courts have ruled that the police or other government officials have no right to invite journalists onto private property, regardless of the circumstances. The courts have ruled that ride-alongs involving the execution of an arrest warrant in a private home violate the Fourth Amendment, which protects us from unreasonable search and seizure. However, the ruling does not prevent photographers from shooting pictures or video from public sidewalks or public streets during such activities. Just as First Amendment rights are not absolute, the right to privacy is not absolute. Privacy rights are limited when the subject is a public figure. Public figures have limited claim to a right of privacy. Past and present government officials, political candidates, entertainers, and sports figures are generally considered by the courts to be public figures. They are said to have exposed themselves to scrutiny voluntarily and to have waived their right of privacy, at least in matters that might have an impact on their ability to perform their public duties. A person who is thrust into the spotlight because of participation in a newsworthy event also has limited privacy rights. A couple of other things to keep in mind. There can be no invasion of privacy if a subject consents. Talk to the subject whenever possible and discuss the newsworthiness of the photographs. Talk to parents and guardians whenever possible too. First Amendment rights should be vigorously protected and exercised, but it is not a license to stampede on the rights of individuals. Newsworthiness should always be the guiding principle. Does your audience need this information to make informed decisions and to better understand the world around them? And your personal conduct is a reflection of your principles. Journalism is about shedding light on people, events, and issues. Be transparent and open about your intentions. The law is on your side most of the time. Just know when it's not.